Thank you very much, Mrs. President. Thank you, the organizers, for inviting me here. I'm very happy for being here again. So my presentation focuses rather on restrictions in the freedom of expression instead of admitting freedom of expression, and I will explain why. So it focuses on the media regulation of AI-generated informative texts under the AI Act. And of course, the context here is what I call algorithmic journalism. Of course, there are other terms. Peter uses robot journalism, for instance, which refers to automatic generation of journalistic content by AI-generated models. So this is not very new. Actually, I think it was the first case in China referring to copyrightability of AI-generated output in journalistic content. So as you can see here, an article of more than 30 years old, where Associated Press uses AI models in order to generate some stories, some articles of journalistic nature. And of course, we're talking about automatic generation, autonomous generation, to be more exact, with minimal or no human intervention in the process. So here is a more recent example. So you have some raw data in the left side, which are fed into an AI model, which is called Wordsmith, and produces some stories, financial stories, in an automatic way. So, okay, this is the context. And of course, we all know that the AI Act is a regulation that focuses basically on the regulation of the AI sector in the EU and maybe beyond. But of course, we all know that it focuses on transparency. And of course, it's already mentioned from the very outset that the purpose of this regulation is to promote the uptake of human-centric and trustworthy artificial intelligence. So the focus here is to be able in understanding first and oversighting the use of the AI. And then the regulation lays down harmonized transparency rules for certain AI systems. And this is where the provision I will focus on is written down. So we have a specific chapter for transparency obligations. It's Article 50 and following. So it's the section where deepfakes are regulated, as we heard yesterday. And among others, what is interesting here is that the transparency obligations are not only focusing on AI system providers, but also, and more crucially, on AI deployers. So this is the provision, it's Article 50, paragraph 4, subparagraph 2. So according to which deployers of an AI system that generates or manipulates text which is published with the purpose of informing the public on matters of public interest shall disclose that the text has been artificially generated or manipulated. So this is the rule, this is the transparency obligation. But then this obligation shall not apply where the use is authorized by law to detect, prevent, investigate, or prosecute criminal offenses. And what is more crucial here, the obligation shall not apply where the AI-generated content has undergone a process of human review or editorial control, and where a natural or legal person holds editorial responsibility for the publication of the content. So we have a provision which sets an obligation and at the same time sets an exception from this obligation. I will focus on the second type of exception, but then before doing that, I would like to focus on the scope of the obligation. So the obligation focuses on text, not on images, not on audio, so it complements somehow the deepfakes transparency obligation. We're talking about published text, and we're talking about published text by deployers of AI systems. And it's here, I think, relevant to remind what is the definition of a deployer? So basically, deployer is a professional user, a user of an AI system that uses the system for, let's say, professional activity. Personal, non-professional activity is not involved. So this is, I think, interesting for the purposes of this provision. And of course, the text should also inform the public on matters of public interest. So not all texts are covered. We focus on specific text and, of course, with specific purpose. And the purpose here is informing the public. I would have the question here why the legislator would like to not stop the sentence in informing the public, why would not this not be sufficient, and adds informing the public on matters of public interest. I don't know why this has to be so specific and why this is a necessary, let's say, clarification of what informing the public is, but from a teleological perspective, I would understand that this addition does not really narrows down the scope of the obligation, because I understand that matters of public interest are, in the end, matters that interest the public. So we're talking about a very broad scope of obligation. And of course, it's not mentioned in the text that we are referring to journalism. But basically, journalism is covered by this provision because first, we're talking about text informing the public for matters of public interest. Of course, this is the main purpose of journalism. And second, we are talking about professional users, which mainly refer to media services, so to professional journalists or press publishers that publish text with this purpose. The purpose of informing the public. We're not talking about a non-personal activity. So, according to this scope of exception, I think that we already have a specific regulation of AI journalism in the EU. So, what is the obligation? The obligation to disclose. Disclose the fact that the text for informing the public has been generated or manipulated. This is also crucial. By an AI system. And of course, the disclosure of obligation refers, I think, to any portion of the text. So it could be a text which is fully AI generated or a text that some parts of it are AI generated or translated. I would suggest that manipulation covers the translation. And what is different from the transparency obligation regarding deepfakes and also the transparency obligation of the general transparency obligation of Article 50, paragraph 1 or 2, referring to the machine-readable mark of AI-generated output. Here, we need to have a human-readable information saying that this text is an AI-generated text, and it should be made, of course, in a clear and distinguishable manner vis-a-vis the informative text. So I understand here that the main focus is that people, when read the news, read articles, when they interact in the end with texts which have an informative purpose, they should be aware from the very first beginning that they read an AI-generated output. So that's the obligation, but then we have the exception. We have an exception that relies to a two-factor condition. First, there is no need for revealing the AI-generated output when the text has undergone a process of human review or editorial control, and where a natural or legal person holds the editorial responsibility. So I find that these two conditions are cumulative. They need to be present both. And I also see here that the question of human review or editorial control is more specific than the more generic human oversight. I think that this should be very targeted. And I understand that human review is not simply human in the loop, but of course It's a more active behavior of the human, trying to detect any errors and, of course, to confirm the accuracy of the informative text which is publishing. And regarding the editorial responsibility, I think that this is the core issue here. The AI Act does not provide any definition for that. But if we try to be systematically coherent within the EU law, which is sometimes difficult, we can find in the European Media Freedom Act a definition of the editorial responsibility, and I would suggest that we can use it also for defining the editorial responsibility in this AI Act provision. And here we can see that the editorial responsibility is a broad concept, is a broader concept than the one we have in media laws in national level, because it's not, let's say, equate the editorial responsibility with the legal responsibility. So it's a rather broader concept than the strict editorial responsibility we know from, for example, in Greece, the objective responsibility of the publisher or the editor. So here, this is just a note of making a systematic link between the two texts. And so, after all, I can see, I have already said, I can see that we have here a specific and ad hoc regulation of AI journalism in the text form in the EU. So it's an EU AI media law. It regulates media in the era of the AI. And I can see that when putting a burden of obligation to journalists and to media services, this might sound as a disincentive for automated journalism. Because I can understand, as a user of media content, I would not be very reliable in a content that it explicitly says that this is an AI-generated content. Because maybe as Professor Mitro, I don't really trust the machine. So I'm not really sure that we're talking about true facts or misinformation. But when at the same time the legislator decides to waive this obligation when you have editorial responsibility and control and human review, that means that in the end, what the legislator tries to promote, I think, is the human-centric, trustworthy AI use in the journalism. And so it incentivizes, in the end, the use of AI means, but it also incentivizes the investment in operational and organizational matters of media services that will be in place, in the end, to prove the existence of this human review, the existence of this editorial control, and the existence of this editorial responsibility. But of course, this is not new, I would say, because it seems that it follows what is the approach from the journalism sector. We have already seen different, let's say, ethical texts and codes of ethics for the AI journalism. And we can always find in there that the humans should oversight and review the text, and that there should be always a human, let's say, legal or natural personal responsibility, editorial responsibility for the AI-generated content. But before finishing, just a remark. Again, from a systematic perspective, if we try to see the whole spectrum of the EU regulations in the digital field and the AI sector, I can see that when we talk about editorial responsibility as a concept which falls within the area of ethical journalism, of trustworthy journalism, I think this is a common principle, a common baseline, according to which if media sector invests in that, it will have some benefits which are lowering the transparency obligations first, and I would suggest that it also gives the possibility to claim copyright and, more accurately, related rights protection via the press publishers' rights in AI-generated output, because when you see at the provision of Article 15 of the CDSN directive, you can see that it refers to content of a journalistic nature. and journalistic nature involves, in my view, editorial responsibility and control. So in the end, we probably see that we have this common approach vis-à-vis the regulation of the media sector and the AI journalism within the EU via several different regulatory instruments. So that was all. Thank you very much, and looking forward to the discussion.